is your election petition updates with me, Mama Vio Swabwaje. Is proudly in association with Petrosol, DBS Roofing and Coa Mixture. Well, the court sits today for a review of the 16th of February ruling in respect of application by Mr. Mahama to reopen his case. Now, last Tuesday, the court delivered a unanimous ruling refusing an application by the petitioner to reopen his case for the purpose of causing a subpoena to be issued and directed at Mrs. Jane Mensah to reappear to be cross-examined. We'll take you live now to the Supreme Court as the panel sits.
The Electoral Commission of Ghana, Nana Abudankwa Akufo-Addo. Please, who is representing the petitioner? Please. My Lord, Nana Opoku Ayuma is representing the petitioner. The Electoral Commission of Ghana, my Lord, Jane Mensah, chairperson, is representing the first respondent. Peter McMahon, my Lord, is representing the second respondent.
Please, my Lord, to Melissa for petitioner applicant. My Lord, I'll be led by Mr. Chipaka. Please just step up with me. Should be here in a minute.
Yes. May it please the court, Justin Amenvo appears for the first respondent with Alexander Samoa.
If it pleases your lordships, I put on call for the second respondent. My lords, with me are my learned friends, Frank Davis, Kwekwe Sifi, and Yao Pong.
Yes.
My Lord, there are two applications scheduled for this morning. One is the stay of proceedings. In view of the fact that both are scheduled for today, and the review will be taken today, I crave your indulgence to withdraw the application for stay of proceedings. For the yeah.
The extension of time. It should also be before the ordinary bench. So that was why we decided that we can take. The lead counsel is now in. Yes.
Very well.
You can take the review.
So Mr. Chiketa will take the review.
My lords, respectfully, we have an application for review before your lordships. Time management, you have 30 minutes. Very well. And there will be no extension of time. I'm sorry, I didn't hear that. There will be no extension of time. The application for review is brought under Article 133(1) of the Constitution and Rule 56 of the Supreme Court rules. I respectfully move in terms of the motion paper and the supporting affidavit. And this review is in respect of our application to reopen our case. And your Lordship's ruling is our first exhibit attached to the application. And in our respectful submission, as our ground A indicates, this ruling was per incuriam section 72 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice. There's no question that in your Lordship's ruling there is no reference whatsoever to section 72 of the Evidence Act. Instead, there's a reference to Black's Law Dictionary, which is an English law text. No reference is made to section 72 of the Evidence Act. Section 72 of the Evidence Act is a statute of Ghana. No reference is made to that, and instead there is a reference made to an English law textbook, which is not what is binding on your Lordships. That is why we say respectfully that that decision was per incuriam section 72 of the Evidence Act. And my lords, the authorities are clear, and we have cited Republic against Tete, which is 2003-2004, Supreme Court of Ghana Law Reports 140, where their lordships in the Supreme Court reversed a unanimous decision that they themselves had given, and they reversed that decision on the basis that they had failed to take into account the Armed Forces regulations, which were part of what their duty was as a court of Ghana. They had failed to take it account. They had failed to take it into account. And so their lordships in Republic against Tete reversed a unanimous decision that they had taken, and they unanimously corrected an error. Now, my lords, in another ruling your lordships have given in this case recently, your lordships have said that even if you did not refer to a certain statute in your judgment, we have not shown that it occasioned a miscarriage of justice. My lords, respectfully, that is fundamental error. Republic and Tete shows that once there is no reference to a statute which is binding on your lordships, we do not need to show further that there is a miscarriage of justice. The failure to apply a statute of the law of Ghana is enough of a miscarriage of justice in accordance with the decision Republic and Tete. And if non-compliance with a statute of Ghana, if that is not a miscarriage of justice, respectfully, I do not know what is a miscarriage of justice. Section 72 is very simple in its terms. Section 72, subject to the discretion of the court in a civil action a party or a person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. Yet, this is what your lordships say in your ruling. At page 5, your lordships say, the question is, how can the chairperson of the first respondent vindicate herself when she is not on trial before us? She has neither been personally sued nor arraigned before this court on any complaint or accusation for which she has to explain or account to anybody. It is the institution, the Electoral Commission she heads, that has been accused by the petitioner of not having performed his role. Now, my lords, I mean, respectfully, that is not even true. We have respectfully brought the attention of this court, her failure, her singular failure to perform her roles. We do not simply come before this court talking about the first respondent as a commissioner. We specifically have raised issues. The heart of this case is about her declaration. But these are the questions. And then your lordships go on. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary defined a hostile witness as so-and-so. There's a whole quotation from Black's Law Dictionary. Then it carries on, in effect, to say that it is only when a witness is in the box that he can be declared a hostile witness. My lord, that is not the law of Ghana. The law of Ghana is not what Black's Law Dictionary is saying, or what their lordships based on Black's Law Dictionary are saying. The law of Ghana is what I read from section 72. That says a party may be called. A party may be called. It's not that when they are in the witness box, then they can be turned into a hostile witness. That is not what the statute law of Ghana says. And my lords, it is fundamental and egregious error when on the basis of Black's Law Dictionary, we have the courts of Ghana going against a statute of the land. Ground B of our application, of our grounds. Ground B says that the ruling was in fundamental error in subjecting statutory provisions in the Evidence Act to the provisions of subsidiary legislation. My lords, there again, nothing could be more basic. Nothing could be more basic than the fact that a statute is superior to subsidiary legislation. The Rules of Court Committee are not of a higher standing than the Parliament of Ghana. And so when you have a judicial decision of the highest court of the land effectively subjecting Parliament's law to the Rules of Court Committee, that is fundamental.
Mr. Chikata.
Yes.
Are you suggesting that CIs do not go to Parliament?
CIs go to Parliament, but they go to Parliament in a different way from how statutes go to Parliament. That is why the Constitution makes a distinction between the exercise of powers by people such as the Electoral Commission, who take the CIs to Parliament, and if there's no objection, it goes through. That is a different process from a statute, which is an act of Parliament which overrides subsidiary legislation. My lords, there can't be any question. And if your lordships have an issue with that, I'm afraid that that is just fundamental error. There can't be any question that subsidiary legislation, such as is contained in a constitutional instrument that brings into effect what the rules of court have done, there can't be any question that those are subordinate to the Evidence Act. There can't be any question about that. So where in your ruling your lordship say that you're not going to apply the Evidence Act because there is a rule of court, and that rule
isn't that the exercise of our discretion which prefaces the section that you read?
My lord, it's that those are not the terms of the ruling. The terms of the ruling that your lordships gave, the terms of your ruling are very clear. And unless the ruling is being rewritten, the terms are very clear. Namely that the evidence section 20, we wish to state that, this is on page 10 of the ruling, we wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38 Rule 3E5. That is what the ruling says. It doesn't say that in the exercise of my discretion, this and that. It doesn't say that. It just says it is not applicable. That is what it says. Nothing more, nothing less.
Mr. Chikata,
yes.
Do you have a list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except my reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with application of the Evidence Act, Section 26. Order 38, 3E5. It reads as follows, that is as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption based on the estoppel by own statement in Section 26, except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of Section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together, and I argued in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence, which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. It didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands was highlighting the importance of ascertaining the truth in matters that were before it. And that was made to displace, in the interest of the right to a fair trial, it was made to displace even international relationships as being something that the court would have reference to. That decision in the case of Chachikata and the Republic is a decision that we have cited in our submissions, and I will not go further into that, except to underline the fact that the Supreme Court of the Netherlands, whose reasoning was adopted by the Supreme Court of Ghana, also considered it appropriate that in the interest of ascertaining the truth, it was of value to the court to call a witness.
Once again, I'm curious about something. If it was so important to you to have a particular person testify for you, why did you not present that as part of your pre-trial positions?
My lords, we could not, for the reason that I've given a few times in this court. At the time, that first respondent's chairperson was the person who had filed a witness statement on behalf of, well, first of all, had filed an affidavit of verification of the case of the first respondent. Subsequently filed a witness statement on behalf of the first respondent. And my lords,
so in essence, you were hoping to rely on her coming to testify and found yourself without that. And that is why now you are asking that she comes as your witness after everyone has closed their case.
My lords,
is that what you're saying in essence?
My lords, what we're asking is for our case, for us to have leave to reopen our case. That witness, as we've indicated, had sworn affidavits in response to our application for interrogatories, in response to our application for stay in relation to that. And in those, she had given every indication that she would testify. We had no reason to believe that she wasn't telling the truth. We had no reason to believe that she didn't mean it when she swore those affidavits. We had no reason to believe that anybody in the court would have assumed other than that she would testify. In fact, the day that it was announced that she would not testify, on that day, your lordship themselves expressed, some surprise, and that was the reason why you adjourned to the next day for arguments to be raised and so on. So, my lords,
Mr. Chikata, when you announced that you had closed your case, what did you mean?
Nothing more, nothing less. We had closed our case. And when we announced that we are seeking to reopen our case, I mean exactly that, nothing more, nothing less. We are seeking leave to reopen our case in circumstances where a person who has deposed to affidavit saying she will be available for cross-examination, and where your ladyship specifically had intimated that the questions that we're seeking to raise in interrogatories could be asked of her in cross-examination. I'm sure your ladyship has not forgotten that bridge. And in that context, your ladyship had said that aren't we crossing a bridge that we have not got to? And we indicated that at the stage of interrogatories, we still found it appropriate to anticipate that. But your ladyship said the bridge will be there. That bridge is no longer there.
When you said that you had closed your case and you meant it, nothing more, nothing less, what did you mean?
I really don't understand what more your ladyship wants by way of an answer. We meant that we had closed our case. And we had closed our case, and subsequently we sought leave to reopen our case. Your ladyship cannot say that we are not able, under the rules, under your inherent jurisdiction, to ask for your leave to reopen your case. I don't believe that that is a suggestion that your ladyship is making.
I don't think I've said any such thing.
So but it's very difficult to comprehend.
I just wanted to understand what you meant when you said you have
I've answered that question, I think, twice or
nothing
thrice
more,
already.
nothing less. And I'm satisfied with the answer, sir.
My lords, we continue finally to the last ground, that the ruling was in breach of Article 296. And my lord, very simply put, what we are saying is that that ruling is completely unreasonable in terms of what are often referred to as the Wednesbury principles. And her ladyship, Justice Georgina Wood, as she then was, in the case of TDC and Musa against Atab Balfour, 2005-2006 Supreme Court Law Reports, page 121. Your ladyship's, her ladyship, at page 131, expressed the specific terms of what such unreasonableness amounted to. And by saying that he, that is the plaintiff in this case, succeeded in showing that the case fell within the irrationality or unreasonable rule, in that the decision arrived at by the TDC defies logic and common sense or accepted moral standards, and that without meaning any disrespect to the TDC, no sensible or reasonable person called upon to apply his or her mind to the decision to be taken could have come to that decision. In short, the decision to throw him out of the house and foist a residential plot on him is irrational and unreasonable. And we are saying respectfully that your lordships, in the exercise of your discretionary powers, unfortunately failed to advert your minds to relevant statutes, introduced irrelevant considerations which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute, justify in the circumstances of this case that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships. And as Aqua,
your time is up.
May I just finish in a minute, because I'm in the middle of a sentence. Is that allowed?
Okay. You may finish.
As Aqua indicated in the Koglex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Order in court, please. Order.
Yes. My lords, we are vehemently opposed to this application for review number 3. Lord, we have filed an affidavit in opposition as well as a statement of case, and we rely on it. Lords, under Article 33(1) of the Constitution, this court may review 133(1), my lords, 133(1) of the Constitution. This court may review any decision made or given by it on such grounds and subject to such conditions the role that is played by the Rules of Court Committee. And indeed, my lord, the Rules of Court Committee has the 1996 CI 16. And lords, the specific rule on review is Rule 54. Lords, this court is the final court of the land. We concede that the court is not infallible. But, my lord, your lordships may change your mind in an application for review only when certain conditionalities have been met. My lords, those conditionalities have been set out in Arta number 2 versus Arta number 2 to 2013-2014, 1 Supreme Court of Ghana Law Reports 569 at pages 579 to 580. Lords, I will not read those conditionalities there, but they are there. Lord, it's only when those conditionalities have been met that the review panel should seriously consider the merits of the application. Lord's, our submission that the conditionalities set in Rule 54 of CI 16 and ATA have not been met by the applicant in this application. Lords, with the greatest respect, the grounds are basically an academic treatise of alleged erroneous pronouncements made by your lordship panel of 7. Indeed, if we want to give some credit to the grounds, my lords, they are at best additional grounds that have been filed without leave of your court in terms of an appeal, but they do not form grounds for review for which my lords should grant this application. My lords, may I refer your lordships to the ruling that has generated this review at pages 11. With your kind permission, your lordships held, accordingly, in weighing the propriety of reopening proceedings to permit new or additional evidence to be led or tendered, the court will typically consider the following broad questions. 1, will the evidence, if it had been presented during the trial, have had any influence on the result? 2, could the evidence have been obtained before or during trial by the exercise of due diligence. Then your lordship conclude that in this application, the petitioner has not given us an inkling of the new or fresh evidence he wants to bring to the fore. Neither has he disclosed how that evidence would advance the cause of his petition. Lord, I believe that this is the crux, this is the ruling that the court made. And in the absence of any attack or any submissions regarding this application must fail. Lord, I submit further that the grounds are very misconceived and have no bearing at all on your ratio that I've set out above. Even as submissions were made by the counsel for the applicant, and even as I'm speaking, still, my lords, the court is still not aware. It still doesn't have the inkling of the evidence that the applicant wants to lead, for which the case should be reopened. And Lord, this leads me to the Wardyear case that was cited by counsel for the applicant. Because in that case, the evidence was known. The evidence was that there was an issue about Exhibit A. And by agreement of counsel, the court then said that let an expert come and testify as to the authenticity of the document. So in that case, the court allowed further evidence just because the evidence that the expert was being called was known. This is not the situation in this case. Lords, what has been done is that there has been arguments that border on the nature of an appeal. Indeed, if my lords look at paragraph 3 of the affidavit in support, with your kind permission, if I may read, he says that at the hearing of this application, I shall, through my counsel, seek leave of this honorable court to refer to all processes filed in this case up to the date of the hearing of this application, clearly indicating to your lordships that he is going to argue an appeal. And that is why your lordships...
It is an application based on previous process.
Yes.
You see, so in motions,
yes,
what you try to do is that instead of seeking leave when you are on your feet, to refer to it,
yes,
you can capture it in the affidavit. Yes. So just as for this one,
no, my lord, if my lord could hear me on the point I seek to make is that as a result of that, the submissions that were, for example, dealt with on the 18th have been brought in. For example, section 26 of the Evidence Act was dealt with. That's the point I seek to make by referring to this submission. My lords, this court has said time without number that the review jurisdiction is not an opportunity given to a party to come and argue the case again as if the review panel is sitting in judgment on appeal over the ordinary panel. And this is what my learned friend has sought to do. Lords, may I crave your indulgence to refer to the Standard Bank Offshore Trust Company Limited versus National Investment Bank. Lords, is civil motion number J7/15/2017. Lords, Doche JSC, delivering the ruling of the court, admonished sore losers at page 17 of the judgment thus: from the ratio, with your kind permission, from the ratio of the decided cases of this court on review, it is immaterial if the applicant for a review considers the decision of the ordinary court to be wrong in law or has an emotional reaction to it, as in this case, the magnitude of the amounts involved or the shutting of the door to applicants because of the effluxion of time in instituting a fresh action. These are not factors that a review bench normally takes into consideration, my lords. Lords, in that case too, the court went on and held that the rules of the court forms an integral part of the laws of Ghana, and consequently, they must be given an equal amount of respect in order to produce the sanctity in court proceedings.
Mr. Menuva,
yes, sir.
Are you referring to me as a sore loser? I argued that application for review before this court. I was studying where you were some few years ago, and I lost that application.
Well, my lords, the review panel forms that view of you. The review panel forms that view of you, my lord, and indeed of your client, my lords. My lords, incidentally, my learned friend was on the other side in that matter, and he got the review. Yes. My lords, the case of Mechanical Lloyd Limited versus Nati again is there on the point. Lords, arguments have been made in this court regarding fair trial. My lords, I ask just a couple of questions of the petitioner. This petition, my lords, has been conducted in a piecemeal fashion, which is one of the things that CI 99 deprecates. First, orders of the court are disobeyed. File, witness statement, no. You yourself intimate that I'm going to call 5 witnesses. You call 2. And then you come back to the court, oh, my lord, I forgot one person, permit me. It is permitted. You call that person. Yes, my lord. Oh, my lords, this is the issue of fair trial. My lords, with the greatest respect, the issue of fair trial has been raised. And now I'm saying that he has been given fair trial in the way the case has been conducted, my lord. Lord, then we go from there to having called the 3rd witness. What is your pleasure? Oh, my lords, I close my case of your own volition. Lords, it is my submission, therefore, that the petitioner was given every opportunity. He was fairly heard in these proceedings. And what has been filed, review number 3, is an abuse of the court processes, and the application ought to be dismissed in limine.
Mr. Menuva, you have not addressed us on the reference to Hosea, the gospel according to Hosea. Yeah.
My lords, I made
order, please.
My lords, my point I wish to make on that, if you permit me, is that God is a God of conscience, and God does not use court processes to elicit conscience. No. God is a cause of conscience, and therefore you do not bring God into the courtroom to now claim that because of God, application should be granted. That's my response.
Isakutampa.
30 minutes. My lords, we are opposed to this application, and my lords, we rely upon our affidavits in opposition filed on the 21st of February, together with our statement of case. My Lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner a miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My Lords, now on ground A of petitioner's application, the petitioner refers to section 72 of the Evidence Act. Now, my Lord, section 72 of the Evidence Act reads thus. 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence. At any time, my Lords, during the presentation of evidence by the party calling the witness. My Lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice, and on both occasions this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to section 72(1), because it was irrelevant to the circumstances of the case. And my Lords, it is my submission that, knowing that they have closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my Lords, all the submissions around section 72 that the court was per incuriam of Section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38, Rule 3E, 5 cannot override Section 26 of the Evidence Act, because in his view, the Evidence Act is a substantive legislation, and Order 36 is subsidiary. My lords, 38, sorry, is subsidiary. My lords, it may well be the case that Order 38, Rule 3E, 5 is subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, Section 26, by itself delimits the application of the main text by the words subject to a rule of law or equity. And my lords, there can be absolutely no doubt that Order 38, Rule 35, is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38, Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court has committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of Parliament. My lords, we would next address Ground C, which relates to Part 459, Section 58. Ground D. My lords, in my respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen the case. My lords, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My lords, this provision presupposes that the party who is applying to summon another has not closed his case. Now, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed its case. And my Lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to mislead those who do not know the law. So, my Lord, it is our respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived and should never have been made by counsel. My Lord, we wish also to make the point here, for the last time, that the chair of the first respondent has never made any undertaking that she would mount the witness box, such that the petitioner could claim that he relied on it to his detriment. My lords, all that the chair of the first respondent did was to repeat what the law is. That is all that he did. The law, and if your lordships go to Order 22, Rule Order 22, all that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking, and it beggars belief that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. My Lord, I therefore wish to submit that a reference to the deposition of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. My lords, the fair hearing argument, my lords.
There are 5 minutes more.
Very well.
10 minutes.
My lord, I thought I had a lot more minutes. Unless your lordship things I've made out my case. So
you have 5 out of the 30. You have 5 minutes more.
19. My Lord, ground E relates to the allegation of breach of his right to fair hearing. My Lord, the right to fair hearing is a right that all parties to a suit are entitled to. So the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box is a breach of the first respondent's right to fair hearing also. My Lord, with our considered view that no evidence or analysis has been made by counsel for petitioner that sustains their claim that their right to fair hearing has been breached. Indeed, this court has been more than accommodating to the petitioner. They defied the court's order with impunity not to file witness statements at the time they were ordered to. They have even again defied the court's order to file closing addresses. And perhaps the court may once again accommodate their defiance of the highest court of this land. And then they turn around to talk about fair hearing. In our respectful view, their case should have been struck out when they failed to file their witness statements as ordered by the court. Or it could have been struck out. And as we speak now, since they have defied once more to file their closing address, this case can be settled without their closing address, and it will be fair trial. My Lord, I'm saying it will be fair trial for that to happen. Possibly the court is once again going to accommodate them. So they should be the last people to be mounting the high horse and talking about breach of their right to fair trial. My Lord, our respectful submission is that this allegation of breach of their right to fair trial is an invitation to the court to go on a frolic which has absolutely nothing to do with the issues before this honorable court as to whether any person, any of the two parties, the petitioner or the second respondent, obtain more than 50% of the valid votes cast in the 2020 elections, presidential elections. My Lord, again, the reference to 296 is in our view quite surprising. Yes, my lords, the court was right in the TDC case to hold that the acts complained of were unreasonable and irrational. But my lords, in the instant application before your lordships, the petitioner has failed once again very badly to demonstrate the facts which ground the allegations of unreasonableness or irrationality. Because those facts, my lord, are based on the grounds that he has dealt with earlier on, A, B, C, D, which we have demonstrated to be hollow and of no merit. Accordingly, my lords, we believe that, and we submit that the application is devoid of merit. It is deserving of a summary dismissal, and given the fact that the arguments are only a rehash of earlier arguments and the introduction of irrelevant provisions for the consideration of this court, we pray that in this exceptional situation, this application be dismissed as an abuse of process. It be dismissed as an abuse of process and cause punitive costs.
Your time is up.
Malted. My lords, we are done.
Who's that?
My lords, may I, with your leave, make a couple of brief references. My learned friend for the second respondent, I heard him a little while ago say that we are acting in breach of the right of the chairperson of the first respondent as far as testifying is concerned, as far as our indication that we are seeking to subpoena is concerned. And my lords, as a matter of law, respectfully, it is not for the second respondent to bring up a witness's claim to immunity, whether on the basis of a right to fair hearing or self-incrimination or whatever. It is not for the counsel for the second respondent to bring up a witness's claim to immunity. The witness must themselves, that witness must, his or herself, I should say, his or herself, put forward whatever claim she seeks to make to immunity. And my Lord, I believe that that was the reason for our reference to the case concerning the IFC's immunity and so on. And my Lord, counsel for the second respondent also sought to suggest that I had somehow sought to mislead the court in terms of section 72. Well, that's a very serious insinuation. Well, it's not actually an insinuation. It was a very express statement on his part. And my Lord, I can only say that counsel is obviously not clear about the nature of the application that is before you. Because the nature of the application that is before your lordships is to seek to reopen our case for the presentation of evidence. That's the nature of the application that is before you. So, reading section 72 about the presentation of evidence and making it seem as if what we are doing is somehow foreclosed because we have closed our case just shows that he hasn't understood why we're in court this morning. Because, my lords, we're in court asking your lordships to reopen our case so that we can go according to certain processes. That's what we're in court for. So for him to be saying that we are trying to mislead you by not referring to during the presentation of our case and so on, my lord, that is just a clear failure to appreciate the terms of section 72. And my lord, he completely does not address the point that we make, that section 72 was not even referred to by your lordships, and that your lordships ruling is per incurium of that section.
Are you done?
Yes, I'm done.
Yes. I have one question for you.
Yes.
Your arguments, you dwell mostly on section 26. Section 26 of the Evidence Act. Can you show me any conflict between section 26 and order 38? Is there any conflict? between section 26 and order 38, 38, rule 3, E5. Is there any conflict?
My lords, I was referring to the fact that the ruling implies that there's a conflict, and that in the ruling it says this section is not applicable because of Order 38.3E. And my lords will notice that I in fact went on to argue. I argued that Rule 38.3E5 in fact has nothing to do with Section 26. Your lordship will recall that I argued that. So I was specifically referring to what was in the ruling. The terms of the ruling are clear.
So it was not a matter of the court preferring subsidiary legislation to substantive.
That's what the court said. I mean, I read it. The court said.
No, we didn't say so.
We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38.
But it doesn't mean that the court was preferring or raising Order 38, raising 38 against above Section 26. That is not what we meant.
Well, my lords, I leave that to your lordships, but the language of the ruling is what I'm referring to. But I leave it entirely to your lordships. The language is that it is not applicable in view of something else. So that other thing is being made applicable, whereas Section 26 is not being made applicable. I mean, there's no running away from that. If you say this is not applicable in view of this, then it means that what is you say is applicable.
Yeah. No.
You're setting aside.
That is what I'm not. It doesn't make it superior to Section 26.
Yeah, but my lord, how can your lordship say that Section 26 is not applicable in view of Order 38?
That is our view.
Yes, but my lords, and that was the other point I was going to make, respectfully, and I'm glad that it has come up. Reference has been made to your ruling in respect of another application in which you did seek to consider Section 26. And there we argued that no reference had been made. It was per incuriam Section 26. In that ruling again, no reference was made to Section 26 at all. In your ruling in that case, your lordship said, effectively, yes, we didn't make reference to that Section 26, but we haven't been shown that a miscarriage of justice has arisen because we didn't make reference to it. And my respectful submission is that, and I did say so, that is itself fundamental error, and your lordship should take the opportunity to correct that error, because you didn't make reference to Section 26, and you sought to justify that by saying that no miscarriage of justice has been shown to you. And my submission was that when you don't apply a statute, there is no reason for miscarriage of justice to be a further ground.
Different from,
I'm sorry.
When you don't make a reference, it's different from not applying.
Well, my lord, if you don't even make a reference, you can't apply. I mean, if you don't even make a reference to it, you can't apply it. I mean, you make a reference to Black's Law Dictionary. Black's Law Dictionary, you make a reference to that. Black's Law Dictionary is not binding on this court. It's stating common law rules which have been changed by statute in this court. But you make reference to Black's Law Dictionary. But you don't make reference to the statute that is binding on you. Well, that is per incuriam. That's
no. That is your opinion.
Well, that is indeed my opinion, and I think it's backed by a plethora of authorities of this court.
The court will rise to consider its ruling.
All rise.
And that's the end of the oral argument today. This has to do with a review of the court's own 16th of February ruling in respect of application by Mr. Mahama to reopen his case. Another attempt to get the Supreme Court to reopen a closed case is what it is. And that is what Mr. Mahama's lead lawyer, Chachi Chikata, seeks to do. And indeed, he's been making the oral argument questioning, essentially, taking the ruling of the court, questioning the ruling of the panel. I will be taking you back to where we have come from, just to give a bit of background, and then you can appreciate where we are in this process. Remember that after the testimony of Mr. Mahama's third witness, Mr. Robert Joseph Metal Nunu, on the 8th of February, the petitioner closed his case. The court then called on the first respondent, the Electoral Commission, to open its defense by calling its witness, Mrs. Jean Mensah. But the EC's lawyer, Justin Amenuvo, told the court that after listening to all the petitioner's witnesses, he thought the petitioner had not provided any substantial evidence in proof of his case, for which the EC had to tick the witness box to testify in answer. Justin Amenuvo therefore wanted the court to determine the petition on the oral testimonies and data presented by the petitioner through his three witnesses. The second respondent, Mr. Kufuado, associated himself with the EC and told the courts he also did not desire to get testimony through Peter McMeno as contemplated. According to lead lawyer Koto Ampao, the petitioner did not discharge the burden imposed on him by law to produce sufficient evidence to back his case, so there was no need for him to offer an explanation. Of course, the petitioner's lawyer, Chachi Chikata, raised an objection and said Jean Mensah filed a witness statement, therefore she had elected to testify. The panel dismissed Mr. Chikata's objection on the basis that the court could not compel the EC to call Jean Mensah as a witness because the High Court Civil Procedure Rules permits the EC to do so. It is based on this that the petitioner wanted the court to reopen the case to enable a subpoena to be served on Madam Jean Mensah so she can appear before the court and testify. Now, we know that that ruling did go against the petitioner, and once again, there is a review because the petitioner, through his lawyer, wants the court to depart from that earlier unanimous ruling. Kojiang Singh is here with me, but we're also joined by a lawyer, Mr. Bobby Banson, joins us via Zoom. We'll just get him into this conversation. Thank you so much for your time. Thanks for being here. Hello, Mr. Banson?
Yes, can you hear me?
I can hear you.
Thank you for having me.
Okay, great. Thank you for joining us. So, you know, we've all been following this procedure, and I'm thinking that the mood today in court in terms of where the petitioner's lawyer came from, things were a bit tense today. I don't know how you would describe what we've seen this morning.
Well, it's as expected. The stakes are very high with this election petition. And of course, the petitioner wants to make sure that with every ruling that comes, they exhaust all possible avenues to overturn the ruling if it's not in their favor. The Supreme Court is the highest court of the land, so you don't have a right of appeal against any of the decisions that they deliver, but you have a right of review. And I believe that it's within the petitioner's right to make that application, except that, you know, when some of the depositions contained in the affidavit in support and some of the arguments, contentions made in the statement of case, and the responses that come out made it very tense, because sometimes there's a thin line between, you know, attacking the judgment, attacking the reasoning behind the judgment, and then attacking those who deliver the judgment. And it's a matter of legal, everybody tried to display his legal wits, you know, what you can do, what you cannot do. So it's interesting. It's good for legal development or the development of the law.
Great. Let me just bring Kojo Yang Singh in terms of the mood and what we've witnessed today. There are some areas that we'll get into with our lawyer.
Yes. It was different. You could tell that the petitioner is, well, the stakes are high. They've always been high throughout this case, but at this point where the foundation of whether they proceed or not is on, it revolves around whether they can reopen their case. So this particular argument that we heard from Mr. Chikata had a certain amount of urgency that was perhaps extra to what we've seen in the past. And he really outlined his arguments in ways that kind of pointed to his legal basis for suggesting that the ruling of the court be, upended. Because in his view, the ruling, it sought to bring in aspects that he would have expected the law could rely on superior sources or superior definitions. He talked about the fact that the rules of evidence were not even referred to, but instead we heard definitions from Black's law. Black's law, which in many instances the Supreme Court has, shall we say, overruled, or superseded with statutes. And he felt that if we already have statutes, why are we referring to Black's law? I don't actually know what the rules of evidence say and how different they are from what Black's law says when it comes to what a hostile witness is or an adverse witness is. And that was the point that Mr. Chikata was referring to. And whether indeed, even if the Supreme Court had recognized Mr. Chikata's arguments about Madam Jean Mensah being an adverse witness or being invited as an adverse witness, whether that would fundamentally have changed the Supreme Court's decision at the end. I don't know these things, but Mr. Chikata certainly took the time to point out every single way in which he felt that the ruling that was handed down by the Supreme Court, did not address the issues as he saw them. But yes, I think that the mood was more tense. Mr. Amenuvo also made his very measured responses. He seemed more in a subdued mood. Same for Mr. Akutuampao in comparison to times when we've seen them quite fiery in their delivery. The fire today was on the side of Mr. Chikata. Very interesting.
Well, the Electoral Commission believes there are no exceptional circumstances or legal basis that warrant the intervention of the court. Indeed, they contend that this review is an appeal in disguise of an early application to serve interrogatories, which was refused by the court on January 19th. I want to get our lawyer back into the conversation. Mr. Banson, again, just like any review, it is very difficult to get the Supreme Court to depart from an earlier unanimous ruling. But you said something earlier. What are you attacking in a review? Is it the ruling? Do you pick each of the grounds or the reasoning and attack, or what exactly? Because sometimes we get confused by the choice of words sometimes.
I understand. I believe that, but for my legal training, I would also have been confused because it almost always seems like another avenue to re-argue the points that was argued before the court earlier, which were not successful. But review jurisdiction of the Supreme Court is grounded in Rule 54 of the Supreme Court rules, and it provides clearly that you have a right to apply for review if you're able to demonstrate exceptional circumstances which have resulted in miscarriage of justice. Now, in all the plethora of cases that were cited, or that as lawyers we cite in support of our application for review, we realize that the most common means of establishing that there are exceptional circumstances that have resulted in miscarriage of justice is where you say that the Supreme Court did not avert their mind to a binding legal principle or a statutory provision, or they did not take cognizance of an exhibit which was before them, or evidence, and which, if they did, would have made the decision go the other way than they did. And so reviews are not another avenue for you to re-argue completely your whole case that you did for which the decision went against you. And that is why in the application for review, you must demonstrate on the face of it the very basis for which you are bringing the review. If you look at the application for review by Mr. Chikata, by the petitioner, he stated clearly that his basis are that, one, the Supreme Court did not avert their minds to the provision of Section 72 of the Evidence Act. And that is the argument that, or the analysis that Mr. Yankson was making, that according to the petitioner, the Supreme Court preferred the definition in Black's Law Dictionary to what was stated in the Evidence Decree. If in the Evidence Act, if if Mr. Chikata is able to demonstrate that the definition in the Black's Law Dictionary is fundamentally different from the definition in the Evidence Act, then Mr. Chikata would have made a case. But I believe that the provisions in the Evidence Act and what is stated in the Black's Law Dictionary are there for everybody to see. It's a matter of wording, it's a matter of choice. And so even if a judge who is seized with the jurisdiction over a matter did not avert his mind to a statutory provision, but the conclusions that the judge arrived at are supported by those statutory provisions, then it would be difficult to say that the mere fact that the judge did not avert his or her mind to that statutory provision means that the judge has erred, for which reason it forms the basis to review, in the case of a Supreme Court, review their decision. And that is a very tough hurdle for Mr. Chikata to look at. The other interesting aspect will be the balance between the subsidiary legislation, which is the rules of court, i.e. the CI 47, which forms the basis of the witness statements which were filed, and then the provisions of the evidence decree. And you would see you heard Justice Mafosa asking Mr. Chikata towards the latter part of his submission, that are you saying that the two provisions are inconsistent with each other? Because you see, before you decide that one law should override another law, you must first decide whether or not the laws are inconsistent with each other. And there have been instances where the Supreme Court have interpreted statutory provisions, which on the face of it may seem inconsistent with a substantive law. But then they've interpreted it to mean that the two of them can be accommodated. And that if you interpret the two provisions purposively, then you would arrive at a conclusion where the two of them can be juxtaposed side by side and they can be applied. And so they are not necessarily inconsistent, but then you must apply them so that they will operate within the same space. And I believe that is one test that the Supreme Court would have to arrive at a conclusion.
Please continue to stay with us. We want to get our court correspondent, Joseph Akablay, to give us, some background filler, if you like. Joseph Akablay joins us from the Supreme Court. Joseph, first of all, I mean, we heard, because we started from the very beginning, so we know who is representing each of the parties. But there was somebody seated right behind Mr. Chikata. Was that Dominic Ayeni?
Yes, Dr. Ayeni was seated right behind Mr. Chikata. There is also Betty Modi, a former Attorney General, who is also seated at that particular spot as well. Okay, all right. So generally, we started by acknowledging that things have been a bit tense today. You were inside there. How was the feeling like? I think that is an accurate description of how things started out today. And I mean, it commenced with the fact that the court did indicate that they were limiting Mr. Chikata to 30 minutes for his submissions. And the responses and the questions that were posed, I mean, have been quite direct. And some words that have been used in some instances are not the kind of words we are familiar with in terms of covering the court, but words like unreasonable, among others, were used quoting various decisions and making reference to various things that have transpired in the courtroom. And so it seemed a bit tense in terms of the interaction from the panel, specifically related to Mr. Chikata and the panel when they were asking questions and the responses that were given. And it's not any deviation from what we have seen in the course of this particular trial, but that did happen again this morning.
I'm curious, Joseph, the issue of the written addresses, do we know if the petitioner has complied with that earlier order?
As we speak now, the information that we have indicates that the first respondent and the second respondent have filed their written addresses. The petitioner is yet to file a written address. And in fact, on Friday, you heard Mr. Chikata make the point that the stay in their opinion was not just seeking to stay the proceedings that the court was built to take for it to take place, aside from the review that it was seeking. So it was seeking to do two things: one, to halt the proceedings, and two, to put the court order on hold. The order is related to the filing of the written address, and so that's what he was bringing the court's attention to. That resulted in that interaction that he had with the Chief Justice for minutes. And so our information that has not been found. In fact, you heard Mr. Kusampao make reference to it again at the latter part of the proceedings. We are even getting an indication that a request may be made for the extension of time to permit the filing of that particular written address But you recall that the court had again indicated on Friday that it reserves the right to waive the filing of the written address completely. When Mr. Chikata had pointed it out to the court that even by way of the rule and how it operates, the procedure is that it has to be filed by the parties in terms of 1,000 and the other response. But Mr. Kusampa responded at that time that it is the case that the court has the right to determine how it proceeds, and the court has determined that it should be filed simultaneously, and so that should be the procedure of it. And Mr. Kusampa did inform the court that until the petitioners file theirs, the court should not make their written address available to the petitioners. So we have also been taking ourselves to try and get copies of what has been filed, and we have so far not been successful.
Joseph, we see two justices not entirely new to this process of review rejoin. Tell us about the two justices.
So there is Justice Amadou Tanko and also Justice Professor Henrietta Mensah Bonsu. And like you pointed out, these are the same two judges who joined the review of the interrogatory ruling. And you recall Mr. Chikata in the course of the argument today made reference to a break. He was referring to Professor Henrietta Mensah Bonsu, who in the course of Mr. Chikata arguing for a review of the interrogatories had asked Mr. Chikata whether the questions that he has seeking to serve on the EC chairperson, whether they could not ask those questions during cross-examination. And so she is part of this panel, as well as Justice Amadou Tanko, formerly of the Court Patrol, who joined the Supreme Court less than 4 years ago. And so that is by way of the composition now. And so the 9 judges came in. And it creates another situation that we saw happen at the other time. You recall on the other occasion, Mr. Chikata had made a point that in terms of the stay of proceedings, it should have been dealt with by the 7-member panel. And in this particular instance, there is a stay of proceedings pending. Then you had the 9-member panel coming. And when Mr. Chikata drew the court's attention that there is a stay of proceedings pending and there is also the review, the court said that he has stayed with the review now, i.e. the 9-member panel. So what it will mean is that once they deal with this and whatever conclusion the court reaches, the stay of proceedings will be remains outstanding, and the court will have to be reconstituted for the 7-member panel. Now come back, and the question will now be again, will the stay of proceedings be moved at that point in time? Or, it obviously depends on whatever they say that the court will take on that matter. Because if they review the decision and hold the view that the petitioner should be allowed to reopen the case, it will mean that what proceedings should take place going forward, it affects how things go, because the subpoena would have to be filed against President Mensah, among other things. And so that is the order of things, and what remains outstanding relates to the stay of proceedings that the original 7-member panel will have to deal with once it's done.
I thought, Joseph, that before Mr. Chikata walked in to address the court on the issue of the review, Mr. Tony Lita, the other lawyer on the petitioner's side, attempted to withdraw the stay of proceedings application.
Yes, so he actually had made reference to that and informed the court. But when Mr. Chikata came in, he did point out to the court that those are matters that are still outstanding, and the Chief Justice at that point responded that in terms of that particular process, it has to be dealt with by the 7-member panel. And so, yes, you are right on that score that there was a bit of a different communication coming from the same side relative to that particular process. Okay.
Joseph, finally, do you have any idea when the panel will return to give a ruling on this matter?
We do not know for now, except that in terms of what we have seen in times past, it mostly takes between 30 to 45 minutes for them to come back. And so that is what we are working with here in the courtroom. And many of those who are in here, not a lot have moved very far away from the court, because as we have seen in times past, it shouldn't take long for the justice to arrive at a conclusion and come back and deliver the ruling.
Let's confirm to us, Joseph, before you go, is there any fresh application before the courts on this election petition?
As it stands now, no. The application has been brought in, which is likely to be filed, has to do with the extension of time for written addresses to be filed. And so if that has not been filed yet, then for now there's no fresh application before the court. The only one that remains has to do with the stay that was already filed, and the review that the court has gone on research to deal with now.
Okay. Joseph Akable, we'll let you go for now. Thank you very much. That's our court correspondent, Joseph Akable. He's sitting through the process in court, and he will be bringing us a lot more. We've got our lawyer also via Zoom, Mr. Bobby Banson. Maybe you can help us with the state of proceedings application and where we are with that. What does it all mean right now?
Well, the stay of proceedings application obviously is because the court had made an order for the parties to file their written submissions for them to give a date for the judgment on the petition. So the stay of proceedings is an attempt to halt the implementation of that process or that order, or the carrying it out by the parties until this current review application is determined. But the filing of the stay of proceedings does not in itself stay proceedings. That is a principle that has been determined by the court. And so the fact that you have filed a stay of proceedings does not, unlike an application for injunction, in itself stay proceedings. That stay of proceeding would have to be determined before you can say that then the proceeding should be stayed. But at the end of the day, that is what the Supreme Court said, despite the filing of the stay of proceedings, the parties should proceed to comply with their order, which I believe that they would. I mean, judging from the way the Supreme Court demonstrated their displeasure with the decision of the counsel for the petitioner not to file their witness statement until that stay is heard, I believe that they would have advised themselves and proceed to file their written addresses, irrespective of the outcome of the present application.
But what is interesting is that last week, when the court got to know that they had not complied with the order, we didn't get the same kind of reaction. There was no strong reaction to that.
Well, the courts, I believe that they are masters of their own rules. Having given that strong reaction in the previous situation, I believe they may want to avoid a situation where they are seen to be being antagonistic towards the lawyers for the petitioners, because the lawyers for the petitioners should know what it's required of them by this stage. And if they give a deadline for you to file and you do not file, remember, you cannot file without them giving you extension of time. So if they get to that bridge, I'm sure they'll find a way of crossing it.
How often do you hear prophetic words in constitutional matters before the Supreme Court? Mr. Chikata quoted Hosea 8:7, and in the end he said, "He who has ears, let them hear."
Well, you would have, it will interest you to know that there are countless court decisions that are began with either is, well, I have not read any quotation from the Quran yet, but there are countless of them that commence with quotations from the Bible. And Mr. Chikata is known to normally premise such argument with quotations from the Bible, and it adds to the beauty of the law. You know, the basis of law, depending on the jurisprudential school of thought that you belong to, it's morality, and the basis of morality for most of us would be the Bible. And so it's not strange, because the Bible has quotations about justice, about delivery of justice, about hearing the other side. You know the story about the woman who kept knocking on the door of a judge, and the judge finally said, "You've been disturbing me for long, let me give you what you want." It's often quoted by judges if people keep coming to them. So it's not unusual, especially with matters involving Mr. Chikata.
Kojo, you want to give some prophetic words too? Because
I had a smile on my face when I heard Mr. Chikata reading Hosea chapter 8 verse 7. They sow the wind and reap the whirlwind. It goes on, by the way, that particular Bible verse, and it talks about how even the labor of the farmer will come to nothing. The stalk will bear, no flour, and even if it does, foreigners will come and eat it. You know, so Mr. Chikata is seeming to sound a very stark and dire warning. But the kernel of that particular verse is that your punishment will exceed your crime. You will sow the wind, but you will reap the whirlwind. You know, and I wonder what in particular Mr. Chikata seeks, to communicate with that. I'm sure in due course we will all get to understand it. But what I found interesting was that one of the judges on the bench, Mr. Amegache, one of the two who have been added.
That would Justice Amadou Tanko?
Forgive me, Nana Amegache is actually already on the panel.
Yes.
The same panel.
On the ordinary panel.
That's correct. He asked for a response to that from the first respondent. I thought that was interesting. The first respondent had completed his remarks without touching on that. But Mr. Amegache wanted to know.
Can I ask Bobby Bunsen something just on this? Mr. Bunsen, I thought issues referred or the other lawyers can make points, comments on points of law. But since this is not law, was it? I don't know what the question is even right now. Is this normal? I guess.
with every proceedings like that, there's what is called the obiter, which is something that just simply refers to by the way. It's not very connected to the essence of the contentions before the court. So I believe that it may have been out of just that they asked the other lawyer to respond. Perhaps if he had any biblical quotation to quote him, he would have referred to it, similar to the encounter between Jesus and the devil on the mountain. It was a battle of quotations.
This is interesting because I know the first time a thing like this came up in courts when the other lawyers attempted to, they were asked not to because they could only come in on the points of law, and this was not an issue of a point. Okay, well, thank you.
This time around,
something else.
Yeah, I wanted to just make a certain observation of, as we were talking about the mood of court today, Mr. Chikata seemed quite fired up in his arguments today. In fact, to the point where he described some of the aspects of the ruling as unreasonable. He also used an expression near the end when he came back to rebut a point that had been made by the respondents. He actually said that for the court to put aside the rules of evidence and go for Black's law was per incurium. Which, and thank goodness for our ability to learn during this election petition, but it means with lack of regard for the law. So here is Mr. Chikata essentially saying that the Supreme Court has set aside the law. And he's saying this in reference to the referral to Black's law when there exists an evidence, rules of evidence, a statute covering that, the Evidence Act. So I found that very interesting. But again, we're seeing Mr. Chikata actually quite bold in his descriptions of the actions of the Supreme Court. And we don't always get instant responses from the Supreme Court to some of these bold proclamations that Mr. Chikata makes. You may have seen in social media commentary how people suggest that Mr. Chikata, perhaps is operating on something similar to Fergie time. For Manchester United fans, Mr. Alex Ferguson had this amazing ability to somehow let the clock stop when his team still had work to do. And it appears that favor that he had with the gods of football, Mr. Chikata appears to have with the gods of law.
Well, it's our election petition updates in proud association with Petrosol, also DBS Roofing and Koa Mixture. Just before we take a breather, Bobby Benson is a lawyer. He's joined us via Zoom. I just want to ask you before we let you go, there was an issue of one of the justices essentially drawing Mr. Chikata's attention to the fact that they take a lot of things into consideration before arriving at any decision. But Mr. Chikata also did say that he was addressing what was in the ruling. We know that a lot of things happen and they consider many things, but would this be maybe, I'm not sure if the first time is appropriate, but where a justice of the Supreme Court is telling you that we consider many other things before arriving at a decision, apart from what you just read in our ruling? And this is your most credible news source. This is JoyNews. Our election petition updates is associated with Petrosol, DBS Roofing and Koa Mixture. Well, the court has been hearing arguments advanced, first of all, by the petitioner, lawyer for the petitioner, Chacha Chikata. We've heard from the lawyers for the first and second respondents in this case. as well, advancing arguments, seeking that the court will rule in their favor. It's an application to reopen a closed case. If you've just joined us, we're waiting for the court to return with a decision. But as we do that, here are excerpts of the arguments advanced in court this morning.
30 minutes. Very well. There will be no extension of time.
I'm sorry, I didn't hear that.
There will be no extension of time.
The application for review is brought under Article 133(1) of the Constitution and Rule 56 of the Supreme Court rules. I respectfully move in terms of the motion paper and the supporting affidavit. And this review is in respect of our application to reopen our case. And your Lordship's ruling is our first exhibit attached to the application. And in our respectful submission, as our ground A indicates, this ruling was per incuriam section 72 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice. There's no question that in your Lordship's ruling there is no reference whatsoever to section 72 of the Evidence Act. Instead, there's a reference to Black's Law Dictionary, which is an English law text. No reference is made to section 72 of the Evidence Act. Section 72 of the Evidence Act is a statute of Ghana. No reference is made to that, and instead there is a reference made to an English law textbook, which is not what is binding on your Lordships. That is why we say respectfully that that decision was per incuriam section 72 of the Evidence Act. And my lords, the authorities are clear, and we have cited Republic against Tete, which is 2003-2004, Supreme Court of Ghana Law Reports 140, where their lordships in the Supreme Court reversed a unanimous decision that they themselves had given, and they reversed that decision on the basis that they had failed to take into account the Armed Forces regulations, which were part of what their duty was as a court of Ghana. They had failed to take it account. They had failed to take it into account. And so their lordships in Republic against Tete reversed a unanimous decision that they had taken, and they unanimously corrected an error. Now, my lords, in another ruling your lordships have given in this case recently, your lordships have said that even if you did not refer to a certain statute in your judgment, we have not shown that it occasioned a miscarriage of justice. My lords, respectfully, that is fundamental error. Republic and Tete shows that once there is no reference to a statute which is binding on your lordships, we do not need to show further that there is a miscarriage of justice. The failure to apply a statute of the law of Ghana is enough of a miscarriage of justice in accordance with the decision Republic and Tete. And if non-compliance with a statute of Ghana, if that is not a miscarriage of justice, respectfully, I do not know what is a miscarriage of justice. Section 72 is very simple in its terms. Section 72, subject to the discretion of the court in a civil action a party or a person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. Yet, this is what your lordships say in your ruling. At page 5, your lordships say, the question is, how can the chairperson of the first respondent vindicate herself when she is not on trial before us? She has neither been personally sued nor arraigned before this court on any complaint or accusation for which she has to explain or account to anybody. It is the institution, the Electoral Commission she heads, that has been accused by the petitioner of not having performed his role. Now, my lords, I mean, respectfully, that is not even true. We have respectfully brought the attention of this court, her failure, her singular failure to perform her roles. We do not simply come before this court talking about the first respondent as a commissioner. We specifically have raised issues. The heart of this case is about her declaration. But these are the questions. And then your lordships go on. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary defined a hostile witness as so-and-so. There's a whole quotation from Black's Law Dictionary. Then it carries on, in effect, to say that it is only when a witness is in the box that he can be declared a hostile witness. My lord, that is not the law of Ghana. The law of Ghana is not what Black's Law Dictionary is saying, or what their lordships based on Black's Law Dictionary are saying. The law of Ghana is what I read from section 72. That says a party may be called. A party may be called. It's not that when they are in the witness box, then they can be turned into a hostile witness. That is not what the statute law of Ghana says. And my lords, it is fundamental and egregious error when on the basis of Black's Law Dictionary, we have the courts of Ghana going against a statute of the land. Ground B of our application, of our grounds. Ground B says that the ruling was in fundamental error in subjecting statutory provisions in the Evidence Act to the provisions of subsidiary legislation. My lords, there again, nothing could be more basic. Nothing could be more basic than the fact that a statute is superior to subsidiary legislation. The rules of court committee are not of a higher standing than the Parliament of Ghana. And so when you have a judicial decision of the highest court of the land effectively subjecting Parliament's law to the rules of court committee, that is fundamental.
Mr. Chikata.
Yes.
Are you suggesting that CIs do not go to Parliament?
CIs go to Parliament, but they go to Parliament in a different way from how statutes go to Parliament. That is why the Constitution makes a distinction between the exercise of powers by people such as the Electoral Commission who take the CIs to Parliament, and if there's no objection, it goes through. That is a different process from a statute, which is an act of Parliament which overrides subsidiary legislation. My lords, there can't be any question. And if your lordships have an issue with that, I'm afraid that that is just fundamental error. There can't be any question that subsidiary legislation, such as is contained in a constitutional instrument that brings into effect what the rules of court have done, there can't be any question that those are subordinate to the Evidence Act. There can't be any question about that. So where in your ruling your lordship say that you're not going to apply the Evidence Act because there is a rule of court, and that rule
isn't that the exercise of our discretion which prefaces the section that you read?
My lord, those are not the terms of the ruling. The terms of the ruling that your lordships gave, the terms of your ruling are very clear, and unless the ruling is being rewritten, the terms are very clear, namely that the evidence section 20, we wish to state that, this is on page 10 of the ruling, we wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38 Rule 3E5. That is what the ruling says. It doesn't say that in the exercise of my discretion, this and that. It doesn't say that. It just says it is not applicable. That is what it says. Nothing more, nothing less.
Mr. Chikata,
yes.
Do you have a list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except my reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with application of the Evidence Act, Section 26. Order 38, 3E5. It reads as follows, that is as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption. A conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption based on the estoppel by own statement in Section 26, except as otherwise provided by law, including a rule of equity. When a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of Section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together. And I argued in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence, which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even